Is probable cause just, does that mean the Department of Justice or whoever's prosecuting is duty bound by law to begin an indictment, or is it just a code that they're supposed to follow?
Probable cause is an evidentiary standard. And the first thing I did when I was made chief of homicide by then U.S. Attorney Ken Weinstein was I studied everything I could get my hands on regarding what probable cause means, because you can't put, no court has ever put a number on it. Now, I'll do a quick tutorial on evidentiary burdens of proof and what they mean.
Please.
So we all know that to convict somebody of a crime at a criminal trial, you need proof beyond a reasonable doubt. Now, no court has said that means 98% of the evidence must prove guilt, because let's face it, you can't plug evidence into a calculator or a mathematical, formulation. You can't do it. But beyond a reasonable doubt, I would say it's got to be 95, 97, 98% of the evidence proves guilt. You have to exclude all possibilities of innocence, right? That's the granddaddy of all evidentiary burdens of proof. But in the law, there are a whole bunch of lesser burdens of proof. For example, to have a jury find your way in a civil case, it's just a preponderance of the evidence, more likely than not, 51%. That's all that's at stake in a civil case, because a civil case is just about money, right? Mm-hmm. So then if you go down below a preponderance of the evidence, 51%, you have probable cause. That is a really important evidentiary standard in the criminal law, because once law enforcement authorities have enough evidence to make out probable cause that somebody committed a crime, that gives them the lawful authority to lock them up or to indict them. Now, what happens when you are investigating a crime and you get to that probable cause level, which I will say, and academics might not like the fact that I say this, the person who decides whether there's probable cause ultimately is a judge, because as a prosecutor, I can investigate and say, I assess that we now have probable cause to arrest someone. I have to put all of the evidence with my FBI agent or my homicide detective in a sworn affidavit and then present that to a judge. And the judge decides yay or nay on the probable cause question. So ultimately, it's up to the judge. So the best thing I ever read about what probable cause means was a nationwide survey of judges, because they're the ones who have to make the decision. Yeah. And the judges they were asked to give it a number. Appellate courts will never give it a number. There's no published case that gives it a percentage of the evidence. But judges said, I'm thinking it's between 42 and 44% of the evidence, an artificial exercise, I know, because evidence doesn't have numeric value. 42 to 44% of the evidence, and then I will sign a warrant, an arrest warrant, because I think there's probable cause. So we know 42 to 44% is below the 51%, right, of preponderance of the evidence. Here's the thing. Interesting. Here's the thing. If I was investigating a case, once I had probable cause, I had a decision to make. Do I arrest that person or indict that person? Because an arrest and an indictment, both of those things require probable cause. Right. Or do I keep investigating covertly before I make an arrest?